Remember that the sudden flash of red and blue lights in your rearview mirror triggers an immediate physiological response that can cloud even the most level-headed driver's judgment. As the weather warms up here in early May and more people take to the roads for spring weekend trips or to enjoy the blooming scenery, the likelihood of encountering a traffic patrol increases significantly. This seasonal uptick in road activity often means officers are more vigilant, and if you find yourself pulled over during these clear spring evenings, your first priority is managing the surge of adrenaline that naturally follows. Your heart might race, your palms might sweat, and your thoughts may begin to scatter as you pull over to a safe spot. This is a survival mechanism, but in a legal context, it can lead to impulsive statements or unnecessary concessions. Take a slow, deep breath and recognize that the physical sensation of anxiety is not an admission of guilt. It is simply your body reacting to a stressful stimulus. By acknowledging this internal state, you can begin to ground yourself, ensuring that when the officer approaches your window, you are acting from a place of clarity rather than panic. As you sit there waiting, perhaps noticing the scent of rain or the way the late afternoon sun filters through the trees during this time of year, you are in a state of heightened vulnerability. This is precisely when the phrase, "This will go a lot easier if you just cooperate," or "Help me out here," is most likely to be used. It is designed to capitalize on your desire to end the stress of the encounter as quickly as possible. However, the legal system does not always reward the kind of cooperation that involves waiving your fundamental protections. Understanding the mechanics of a traffic stop is the first step in maintaining your composure. The officer is performing a job, following a specific protocol designed to gather information and ensure public safety. Your role is not to be an antagonist, but rather a calm, informed participant who understands the boundaries of the interaction. Thinking clearly means recognizing that the officer's convenience is not the same as your legal best interest. You can be the most polite person on the road without sacrificing the rights that are woven into the fabric of the law. To maintain this clarity, keep your hands visible on the steering wheel and avoid making sudden movements while the officer is checking your plates or approaching the vehicle. This isn't just about safety, it's about setting a tone of professional, predictable behavior. If you feel the urge to speak immediately to explain yourself or ask why you were stopped, try to resist it until the officer initiates the conversation. The silence between the moment you stop and the moment the officer speaks can feel like an eternity, especially when the spring air is still and the world outside seems to have paused. But that silence is your friend. It gives you the space to remind yourself of your plan, to be respectful, to provide necessary documentation, and to remain silent regarding any questions that delve into your activities or intentions. By focusing on your breathing and the physical sensation of the steering wheel beneath your hands, you stay present. This presence is your greatest asset because it prevents you from falling into the trap of oversharing out of nervous energy. You are not there to win an argument on the side of the road. You are there to navigate a procedural event with your dignity and your rights intact. The goal is to move through the encounter without providing the evidence or admissions that the officer might be fishing for under the guise of making things easier. When you hear those words, it should act as a mental trigger, a signal to double down on your composure and your commitment to your constitutional protections. This early May period often brings with it a sense of renewal and movement, but on the side of the highway, time needs to move at your pace, not the officer's. You have the right to think before you speak, and to ensure you aren't being coerced into a disadvantageous position through psychological pressure. Staying calm is a skill that can be practiced, and it begins with the realization that you are the primary advocate for your own legal standing in that moment. The typical stop is a choreographed dance of authority and response. By staying grounded in your nervous system, you ensure that you aren't being led into a misstep that could have long-term consequences. As the officer finally reaches your window, That initial wave of panic should have subsided, replaced by a firm, quiet resolve to handle the situation with the precision of someone who knows exactly where they stand under the law. Once the officer reaches your window and asks for your identification and vehicle documentation, the physical interaction truly begins. This is the moment to demonstrate that you are a cooperative, law-abiding individual without surrendering your right to remain silent about your day's activities. In almost every jurisdiction, you are legally required to provide your driver's license, vehicle registration, and proof of insurance upon request during a traffic stop. Doing so promptly and politely is the single most effective way to de-escalate the tension of the encounter. Before you reach for any of these items, especially if they are in a glove compartment or a bag that isn't immediately visible, it is a best practice to state your intentions clearly. You might say, "Officer, my registration is in the glove box. I'm going to reach over and get it now." This level of transparency removes the element of surprise and signals to the officer that you respect their safety concerns. It transforms a potentially volatile moment into a standard administrative transaction. Remember to keep your movements slow and deliberate. The goal is to create an environment of professional predictability where the officer feels in control of the scene's safety, which in turn reduces the likelihood of a high-stress confrontation. When you hand over your documents, do so with a neutral expression and a calm demeanor. You do not need to be overly chatty or attempt to make jokes to break the ice. Often, brevity is interpreted as respect for the officer's time and the seriousness of the procedure. By focusing strictly on the task of providing documents, you set a boundary that this is a formal legal interaction, not a casual conversation. While the officer is reviewing your documents, they may begin to ask questions that seem conversational but are actually investigative in nature. They might ask where you are headed, where you have been, or if you know why you were pulled over. It is at this precise juncture that the phrase, "It will go easier for you," often makes its first appearance. The officer may imply that by answering these questions, you are showing good faith, which could result in a warning rather than a citation. However, it is vital to understand that you can be perfectly polite and respectful while declining to provide information beyond your identifying documents. You might respond with something like, "I prefer not to discuss my day, but I am happy to provide my license and registration." This transition is often the hardest part of the stop for drivers because it feels counterintuitive to be unhelpful when you are trying to be polite. But true de-escalation comes from a place of firm boundaries, not from giving away information that could be used against you later. You are providing the government with the information it is legally entitled to, your identity and the legal status of your vehicle, and nothing more. By sticking to this script, you maintain a level of dignity and control. You aren't being difficult, you are being precise. The officer is trained to look for inconsistencies in stories, and by providing no story at all, you eliminate the risk of a simple slip of the tongue being interpreted as a lie. Using respectful language such as officer, sir, or ma'am can go a long way in maintaining a professional atmosphere, but it should never be confused with submission to an overreach of authority. If the officer asks for your phone number or other personal details not found on your license, you have the right to ask if that information is required by law for the stop. Usually the answer is no, and you can simply state that you'd prefer to keep that information private. This is not about being a difficult driver. It is about recognizing that every piece of information you volunteer becomes part of a permanent record. De-escalation is a two-way street, and by providing your paperwork without a fuss and keeping your hands visible, you have done your part to ensure the officer feels safe. This safety is the foundation upon which a calm interaction is built. If the officer continues to push for more information, remain a broken record of polite refusal. "I understand, officer, but I'm not comfortable answering questions about my travel plans." This keeps the focus on the administrative task at hand, the reason for the stop itself, rather than an open-ended investigation into your life. You are managing the interaction by narrowing its scope. When you hand over that plastic card and those paper forms, you are fulfilling your side of the social contract on the road. You are demonstrating that you are a licensed, insured driver who understands the rules, and that includes the rule that protects you from self-incrimination. This phase of the stop is about the what. What is your name and what are you driving? Not the why or the where. By keeping the window interaction focused on these essentials, you prevent the stop from spiraling into an interrogation before you even realized what was happening. You are the professional in your seat, just as they are the professional at your door. And a successful exchange of paperwork is one where both parties remain safe and the driver's rights remain uncompromised. The moment an officer moves from checking your license to asking questions about the contents of your vehicle, the nature of the stop has fundamentally shifted. They might ask, "You don't have anything in here I should know about, do you?" Or more directly, "Do you mind if I take a look in your trunk or under the seats?" This is often the point where they offer the incentive. "Look, if you just let me check, this will go a lot easier and we can both get out of here sooner." It is crucial to understand that this is a request for consent, and consent is a powerful legal waiver. When you give an officer permission to search your vehicle, you are essentially telling the court later that you voluntarily gave up your right to privacy. The legal concept of consent is binary. Once you grant it, the officer generally has a broad scope to look through your personal belongings without needing a warrant or even a specific reason. You must realize that saying no to a search is not an admission of guilt, nor is it a sign of being difficult. It is the exercise of a constitutional protection that exists for every citizen, regardless of whether they have something to hide or not. The law is designed so that you do not have to prove your innocence by opening your private spaces to government inspection. If you hear the officer frame the search as a way to clear things up, remember that their job is to investigate and your job is to protect your legal position. A search that turns up nothing might still result in your vehicle being left in disarray or you being detained for a significantly longer period while they meticulously check every corner. Beyond the concept of consent, you should be aware of the plain view doctrine, which is a high-level legal principle used across the country. This means that if an officer sees something illegal or incriminating in plain sight, like on your dashboard, the passenger seat, or even the floorboards, while they are standing where they have a legal right to be, they do not need your consent to investigate further. Plain view essentially means that if the public could see it through your window, you no longer have a reasonable expectation of privacy for that item. This is why keeping a clean and organized vehicle is more than just an aesthetic choice. It ensures that there are no misunderstandings or visual cues that could lead to a more intrusive search. However, the trunk, the glove compartment, and closed bags are a different matter. These are areas where you have a high expectation of privacy, and an officer typically needs either your consent, a warrant, or probable cause to look inside them. Probable cause is a specific legal standard, a set of facts and circumstances that would lead a reasonable person to believe a crime has been committed or evidence is present. By refusing consent, you are requiring the officer to rely on their own observations and the legal standard of probable cause, rather than relying on your permission to bypass those requirements. It is a vital check on the power of the state. The phrasing you use when refusing a search is just as important as the refusal itself. You want to be clear, unambiguous, and firm. A statement like, "Officer, I do not consent to any searches," is the standard response. Avoid using soft language like, "I'd really rather you didn't," or "Is that really necessary?" Because an officer or a prosecutor could later argue that your language was hesitant or that you eventually acquiesced. When you state, "I do not consent," you are creating a clear record of your intent. The officer might respond by saying, "If you don't let me look, I'll have to call for a canine unit. Or, only people with something to hide refuse a search. These are common tactics used to pressure you into waiving your rights. You must stay calm and repeat your position. I understand, officer, but I do not consent to any searches. It is also important to know that while the core concepts of consent and plain view are widely recognized, the specific ways they are applied can vary significantly from one state to another. Some jurisdictions have stricter rules about when an officer can even ask for consent, while others provide more leeway for investigative detentions. Because these laws are complex and subject to change, you should always treat this information as a general educational framework rather than a universal absolute. Your best course of action is to verify the specific search and seizure laws in your home state and any state you plan to travel through. If you are ever unsure, remember that you are not a lawyer and you are not required to act like one on the side of the road. Your primary goal is to maintain your boundaries and wait for the situation to resolve, knowing that any legal challenges to the officer's actions are best handled later in a courtroom with the help of a qualified attorney. There comes a point in some traffic stops where the atmosphere shifts from the administrative task of writing a ticket to something much more serious, and recognizing this transition is vital for your legal protection. This is what we call the escalation edge. You might feel the pressure mounting if the officer begins asking more probing questions about your history, your companions, or the specific contents of your vehicle, often moving away from the initial reason you were pulled over. When you hear the phrase, "This will go a lot easier if you just tell me the truth," or, "I'm trying to help you out here, but you're making it difficult," you are likely standing at the threshold of a criminal investigation rather than a simple traffic enforcement action. It is essential to understand that, at this stage, the officer's primary role has shifted. They are no longer just looking for a reason to clear the scene. They are actively looking for evidence to justify an arrest or a further search. In these moments, your most powerful tool is not your ability to explain, persuade, or negotiate, but your ability to remain silent. Silence is often misinterpreted by drivers as an admission of guilt, but in the institutional reality of the legal system, it is a protected right designed to prevent individuals from being coerced into providing the very evidence that will be used to prosecute them. You must understand the principle that anything you say can and will be used against you, but the things you do not say cannot be twisted into a confession or a contradiction. Staying safe during this escalation means avoiding any physical or verbal resistance, even if you believe the officer is being unfair, biased, or overstepping their bounds. Your safety is found in your silence and your composure, not in a roadside argument that you are structurally unable to win. Invoking your right to remain silent should be done clearly, directly, and respectfully to ensure there is no ambiguity in the record. Rather than simply stopping speech, which can sometimes be perceived as a tactical delay or a sign of hostility, you can use a specific phrase that asserts your legal standing without being inflammatory. For example, you might say, "Officer, I am exercising my right to remain silent, and I would like to speak with an attorney before answering any questions." Once you have made this statement, the legal principles suggest that interrogation should cease, though you must be prepared for the fact that an officer may continue to speak to you or ask questions to see if you will re-engage. You must be mentally prepared for the psychological pressure that follows such an assertion. The officer might suggest that only someone with something to hide would ask for a lawyer, or they might try to appeal to your sense of fairness by saying they can't help you anymore if you won't cooperate. You must stay factual and stay firm in your resolve. You are not required to provide a narrative for their investigation, and you are not required to justify your choice to remain silent. The concept of counsel is not just a formality for the courtroom. It is a fundamental protection that begins the moment your liberty is at stake on the side of the road. An attorney is trained to navigate the complexities of the law and to ensure that your rights are not marginalized during the investigative process. You cannot out-talk a professional who is trained in interrogation techniques, and trying to do so often leads to minor inconsistencies that a prosecutor can later use to damage your credibility, even if you are entirely innocent of any wrongdoing. During these high-pressure moments on the escalation edge, it is essential to focus on the objective facts of the encounter as they are happening. You should make a mental note of the officer's name, their badge number, the patrol car number, and the specific sequence of events, including the time of day and the weather conditions. If the situation continues to intensify and you feel that your rights are being violated, do not attempt to litigate the matter with the officer on the shoulder of the road. The side of a highway is a place for physical compliance with lawful orders, not for a legal debate or a contest of wills. If an officer orders you out of the car, you should comply slowly and keep your hands visible at all times to maintain physical safety. If they proceed with a search of your person or your vehicle, despite your clear statement that you do not consent, do not physically interfere or try to stop them. Your day in court is a literal concept. It is a process that happens in a controlled environment before a neutral judge, not under the glare of a flashlight in the dark. Staying factual means keeping a precise record of what transpired so that your attorney can later challenge the legality of the stop, the search, or the detention. The edge of escalation is a test of your personal discipline and your understanding of the law. By remaining silent and requesting counsel, you are essentially freezing the legal record in a way that protects your future options. You are choosing to let a professional handle the complexities of your defense, rather than attempting to navigate a high-stakes legal minefield while your nervous system is in a state of fight or flight. Finally, remember that the goal of staying calm and factual is to ensure you return home safely and with your legal options fully intact. The easier path promised by an officer is frequently a shortcut to a self-inflicted legal wound. The truly easier path, though it feels significantly more difficult and uncomfortable in the heat of the moment, is the one where you exercise your rights with quiet, unwavering confidence. You do not need to be an expert in every local statute to know that silence and the request for counsel are your primary shields against overreach. This mindset allows you to detach emotionally from the officer's investigative tactics and maintain your dignity. If the officer becomes frustrated or impatient because of your silence, you must recognize that their frustration is a result of their inability to bypass your protections, and it is not your responsibility to alleviate that frustration by compromising your position. Your responsibility is to your own legal well-being and to the integrity of the process. By refusing to engage in the easier trap, you are preserving the possibility of a successful defense later. The transition from a routine stop to a high-stakes escalation is a moment of profound importance, and your ability to transition from a polite, cooperative driver to a silent, rights-aware citizen is the defining factor in how that encounter will be resolved in the long run. Stay safe, stay factual, and let the law work the way it was intended, by allowing your silence to serve as the ultimate protection of your liberty. The moment the patrol car's lights disappear from your rearview mirror and you are left alone in the quiet of your vehicle, your work is not yet finished. While the immediate stress of the encounter may be subsiding, the window for capturing accurate, high-quality information is at its peak. This is the time to adopt a documentation mindset. Before you pull back into traffic or continue your journey, take several minutes to record exactly what happened while the details are still fresh in your mind. Use your smartphone's voice memo app or a physical notepad to dictate or write down every detail you can recall. Start with the basics: the date, the exact time, and the specific location of the stop. Note the weather conditions, the visibility, and the reason the officer gave for pulling you over. If you didn't get the officer's name or badge number during the interaction, try to remember the patrol car's number or any identifying markings on the vehicle. Most importantly, try to reconstruct the dialogue as accurately as possible. Note specifically when the officer used phrases like, "This will go easier if you cooperate," or "Help me out here." These details are not just for your own memory. They are the raw materials that a qualified attorney can use to evaluate the legality of the stop and the officer's conduct. Documentation is your way of preserving the truth against the passage of time and the natural degradation of memory that occurs after a high-stress event. By acting quickly, you ensure that your side of the story is anchored in facts recorded in the immediate aftermath, providing a counter-narrative to any official report that might be filed later. In addition to your own notes, consider any external evidence that might have been captured during the stop. If your vehicle is equipped with a dash cam, ensure the footage is saved and backed up immediately. If you had passengers, ask them to write down their own accounts of what they saw and heard without comparing notes with you first, as independent recollections are often more persuasive in a legal setting. Pay close attention to the sequence of events. How long were you detained before the officer issued a citation or let you go? Did the officer ask for consent to search? And if so, at what point in the conversation? Did they continue to ask questions after you invoked your right to remain silent? This level of detail is crucial because the law often hinges on the timing and justification of each phase of a traffic stop. A detention that lasts longer than necessary to address the initial reason for the stop might be legally problematic, but proving that requires a clear record of the timeline. You are essentially becoming the lead investigator of your own experience. This disciplined approach to documentation transforms you from a passive participant in the legal system into an active advocate for your own rights. It moves the focus away from the emotional weight of being pulled over and toward the objective reality of the encounter. This mindset is what separates those who are merely lucky from those who are truly prepared to defend their interests. It is vital to emphasize that the information shared throughout this discussion is intended for general educational and informational purposes only. It does not constitute legal advice, nor does it create a lawyer-client relationship between us. Laws regarding traffic stops, searches, seizures, and the right to remain silent can vary significantly from one state to another and are subject to frequent changes through legislative action and court rulings. What is legally permissible in one jurisdiction might be viewed differently in another. Because every situation is unique and the stakes are often high, you should never rely solely on a video or an online resource to handle a specific legal matter. If you have been issued a citation, arrested, or believe your rights were violated during a traffic stop, it is imperative that you seek the guidance of a qualified attorney licensed in your jurisdiction. A local legal professional can provide advice tailored to the specific facts of your case and the nuances of your state's laws. Use the principles we've discussed as a foundation for understanding your rights, but let a professional guide you through the actual legal process. By staying informed, staying calm, and seeking professional counsel when necessary, you are taking the most responsible steps possible to protect your liberty and navigate the complexities of the American legal system. Knowledge is a powerful tool, but it is most effective when combined with the expertise of a dedicated legal advocate who can fight for you in the courtroom. Always verify your local statutes and remember that your best defense is a proactive, informed, and documented approach to every interaction with law enforcement.